Welcome, everybody, to the January 2026 review of the cases published by the Court of Appeals during the month of December 2025. We're going to discuss the labor and employment law cases, the most important cases that we were able to find. Today, we're joined by George Bean, who is a workplace attorney, workplace investigator, mainly representing employees. I am Javier Rivera Carbone, workplace attorney, workplace investigator, mainly representing employers. And our sponsor today is Veritas Workplace Investigations. If you need a workplace investigations in English or Espanol, contact Veritas Workplace Investigations. George, this morning we're going to begin by discussing a case which I'm going to read as Quilala v. Securitas Security Services. And if you can please discuss that case.
Absolutely. I don't have as great an accent as you, but the Quilala versus Securitas case is super interesting. This involves the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, which was enacted in March of 2022. That most employment lawyers should have heard about this by now. If not, you need to read up on this immediately. This is a get out of arbitration free card for cases that involve sexual assault and sexual harassment. Over the last couple of years, it's been a little bit difficult because a lot of the actions had arisen before the act, and the act became effective the day that it was passed on March 1st, 2022. But as some time has gone by, it's probably going to cover most of your sexual harassment and sexual assault cases that you have. So look into this. The important thing that we're going to talk about today is whether the EFAA is implicated or not. And it's only implicated if the FAA controls the arbitration agreement. Now, most of the arbitration agreements that I see, the FAA does control it, and thus it preempts any of the California statutes that get you out of arbitration, such as Labor Code 229 and Labor Code 432. 229 is for wage and hour, 432 is for sexual harassment. But those are preempted by federal law. And so if your arbitration agreement is governed by the FAA, you don't get to access those California statutes. So it's incumbent upon courts who are facing a motion to compel arbitration to conduct a threshold investigation into the controlling law of the arbitration agreement. And it's not just something that they need to respond to if the parties bring it up. They have an independent obligation to establish the underlying threshold law. So in the Quilala case, what happened was the parties didn't even bring it up. They didn't even mention, is it FAA? Is it CAA? And so the Court of Appeals said, you have an independent obligation to bring it up. And the trial court did look into it, and the parties who were complaining about them bringing it up on their own ended up being overruled by the Court of Appeal, who said they have to do this threshold investigation. It doesn't matter if you bring it up. It doesn't matter if you argue about it. It only matters that it exists, and the court must do it. If not, they're committing an error that can probably create an overturn on appeal. So the facts of this were pretty straightforward, although the interesting part was that it wasn't a standard sexual harassment. It was a sexual orientation harassment case based on gender stereotyping and some other factors. And so when the defendants moved to compel the arbitration, the trial court denied the motion, concluding that the EFAA rendered the arbitration agreement unenforceable. And then the Court of Appeal affirmed, saying it doesn't matter that they brought this up on their own. They have that independent obligation to determine the applicability of the EFA, even if not expressly raised by the parties. And so, Javier, do you have any comments on this case?
George, I think this is a fascinating case because, as you mentioned, the parties did not bring it to the court's attention that there was a federal law that had an impact on the arbitration and the arbitrability of the claim. Now, to me, what is really interesting is that this is one of those laws that came as part of the Me Too movement, a federal law that says that if the case deals with sexual harassment or sexual assault, it should not go to arbitration. And as you mentioned, it should be straightforward. And in this case, nobody even brought it up. The Court of Appeal did. But my question to you, George, if this is so straightforward as if there's sexual harassment, if there's sexual assault, there's no arbitration. Are you aware of any issues out there in the trial courts?
The defendants will do almost anything they can to get out of arbitration, especially in a sexual harassment and a sexual assault case. They really don't want this company in front of a jury. And so, yes, there's a bunch of technicalities having to do with the dates, what I mentioned at the beginning. Some of these causes of action may have arisen before 2022. Like I said, now that some time has gone by, that's less likely. But there's also the wording of the EFAA, and there's also the word elect, meaning that the plaintiff has to elect to avoid arbitration. Yet the Court of Appeal said the mere fact that they filed in court, that was their election to avoid arbitration. So sure, the defendants are going to try anything they can, but the courts are really starting to skew in favor of the employees in the EFAA cases.
So this is what I think I heard you say, that although the statute said that the employee has to elect arbitration, what the courts in California, at least this Court of Appeal, is saying that filing a claim in court is equivalent to choosing the no arbitration for this types of claim. Did I get that
Uh,
right?
Absolutely. And like I say, the defendants' attorneys, of course, are going to they're going to leap on every single word, including elect. But here the Court of Appeal said, nope, you don't get to split that hair. And so I'm seeing the defense do this, but I'm seeing the courts knock that down piece by piece.
I cannot blame any employer trying to avoid a jury. However, if the wisdom of the Congress was to create a law that is pretty straightforward, then that's that. George.
I agree. And one more note on this is that threshold uh, analysis about the FAA is not a death knell for the plaintiff, because if they decide that the FAA does not apply to the arbitration agreement, you have the California statutes that spring to life and allow you to go to court. And the EFAA has a really special little fun piece to it where if you have a sexual harassment claim, the entire case gets a jury.
And what I also heard you say is that there are some California laws that will have the same effect. If federal law, arbitration law does not apply under California law, the case is not going to arbitration either because of the sexual harassment allegations, right?
Correct. But as I mentioned earlier, they don't have that special little feature where the entire case automatically gets to go before the jury just because there's a sexual harassment claim. In California, I could see employers making the argument that we bifurcate the case. I don't know how the court would decide that. And we do have Labor Code 229, which throws the wage and hour cases out of arbitration as well. So maybe it's a distinction without a difference. Maybe you have to rely on two statutes instead of one.
Interesting. But this is a case that definitely everybody that deals with these types of cases, and I mean by that sexual harassment cases, have to read when there is the potential of forcing arbitration in the claim. Thank you, George. Let's also move to another cases that we have gathered. The cases are not as important as the one that you just discussed, in the sense that what you mentioned in the Quilala case is big and important. It changes the law. But the other cases I would like to mention, and I would like for you to join me in mentioning, because it is important for everybody listening to this recording to know about it, but the play-by-play is not that important. And the first one that I would like to mention is the one titled Sierra Pacific Industries Wage and Hour Cases. And what happened in that case is that the employer litigated, and this was a class action case. And after motions, the trial court ruled and certified a class. After class certification, then the employer brought up the fact that thousands and thousands of employees had signed an arbitration agreement. And for that reason, they were required to arbitrate their wage and hour claims and not have a class. The Court of Appeal ruled wisely, I think, that it was too little too late, because there is a solid string of cases for the proposition that if you engage in litigation, that action is a waiver of your right to arbitrate. So litigating is going to preclude arbitration because you either arbitrate or you litigate in court. You cannot do both. And in this case, it's so extreme that they did it after class certification. And for that reason, it was not a surprising result. But I think the court is sending a message to everybody. Don't do it too late if you're going to do it at all.
This is really interesting as well. Often defendants will move to compel arbitration after the initial pleadings. And it's in the past been hard to establish waiver. How much litigation has to go on before we have a waiver of the right to arbitrate? But this one seemed pretty egregious to me after class certification. That doesn't happen at the beginning. It takes a while, right? And so they produced thousands of arbitration agreements. Not only did the court deny it, like you said, they imposed evidentiary and issue sanctions for discovery misconduct as well. So from the plaintiff's side of the bar, bravo, bravo. It's also just, I hate to say it, it seems typical of a defendant to hide those arbitration agreements until after class certification. So if this was intentional, it backfired.
I cannot push back. It's hard to defend somebody who brings arbitration after certification, class certification, which requires a hearing, evidentiary hearing. So it's definitely too little, too late. Changing subjects now, I would like, George, for you to discuss the case of Contreras v. Green Thumb Produce, Inc. What happened in that case?
This is another interesting case where an employee brought a retaliation claim under Labor Code 1102.5, and he relied on guidance about whether what he was claiming was unlawful or not. And that guidance turned out to be wrong. So the question is, does his retaliation claim survive when he was wrong about whether the employer broke the law or not? Well, the way 1102.5 reads is that the employee only has to have a reasonable cause to believe that a legal violation occurred, even if it's based on a mistaken interpretation. Here, the employee relied on guidance from the Labor Commissioner's office and from some frequently asked questions on the internet page of the Equal Pay Act. So the court ended up finding that it was reasonable for this non-lawyer, for this layman, for this employee, to believe that a violation of law had occurred. Didn't matter that he was wrong. He was reasonable at the time. He made the complaint. He got fired. So the retaliation happened, according to the jury. The only question was, did he make a reasonable complaint? And that's, part of the elements of the cause of action. So it has to be there. But the court found, doesn't matter if he's wrong, as long as he was reasonable.
And on that question, I disagree. I dissent. Because the question here was whether the employee reasonably believed that the employer broke the law. And the employee admitted that his belief was not based on the reasons listed by the law. So if the law makes it illegal, equal pay, and the employee admits that none of the legal reasons apply to his case, that he was just based on what the internet says, the government agency says, and the jury found in favor of the employee, this is a slippery slope, a dangerous slippery slope, I think. Because the Court of Appeals said that the threshold question, or the question that needs to be answered by the trial court, is whether the employee reasonably believed that the employer acted illegally. And in this case, it was based on the opinion of a government agency. Well, if I go to certain government agencies today, on January 2026, there are some things that are going to be said there that are not reasonable. So do I have a case now because I'm following the unreasonable guidance of a unreasonable government agency? I see danger all around. This is not good. Not good for justice, George.
I don't think this case holds that believing what a government website tells you is equivalent to being reasonable. Those are the facts of this case, but I don't think that's the holding of the case. I think if you look at the name of the cause of action, it's called retaliation. It's not called reasonably believed. And so did the retaliation occur? And so I think the court and the jury correctly determined that yes, retaliation occurred, and the splitting hair of whether he was reasonable to believe what a website said or not isn't really the point.
But not all retaliation is illegal. If I terminate you because you broke one of the rules of conduct, if I terminate you because of lack of performance, that is retaliation by definition, but it's not illegal. What is illegal is when the retaliation or the bad action against the employee is motivated by the employee exercising a right. And in this case, the employee admitted before the jury that the reason why he thought he was not being paid the same was not protected by law. So if there is no violation of the law, how can there be retaliation? I see danger all around.
Well, I think what we have here is a squeaky wheel, and we have a fact determination. I don't think the whole reading of a government website established a new law. I think what we had is a jury who found factually that they believed that this employee reasonably believed what he was saying, and that the employer retaliated against him for making that claim.
So we'll see what happens with this case. This may become one of those rare cases that goes as, nothing happened, move on. Or this is one of those cases that is going to chip away from the defenses that the employer has, because if there was no illegal conduct, there shouldn't be any retaliation. But I guess we agree to disagree on this one. So Contreras, write it down, read it. Interesting. It could go either way. Now I would like to mention the case of Dieves versus Butte Sand Trucking Company. This is a fascinating case. I just want to mention that this is a complex case, but a straightforward case. Complex in the sense that this case deals with truck drivers, and some truck drivers, based on the work they do, may be exempt from the California Labor Code, subject to federal regulations. And what that means is that some truck drivers, they don't need to have rest breaks. They don't need to have meal breaks. Now, in this case, what happened was that there was a class action, and there was also a PAGA action for penalties brought, and the employer tried to make those cases go away because of the applicability of the federal regulations. And the trial court ruled a couple of things concerning the class action and concerning the PAGA. The trial court seems to have dismissed part of the case, but allowed part of the case to continue. When it went to the Court of Appeals, the Court of Appeals reviewed everything, and the holding in this case seems to be that because the trial court decided that the PAGA case for penalties was not manageable, and because it was unmanageable, it should be dismissed. The Court of Appeals said that trial courts do not have the authority to rule dismissal of PAGA claims based on unmanageability or the failure or incapacity to manage the case. And that's a big deal, because if the trial court is saying that there is no way to manage this in a trial, and if it is not manageable, how can the court deal with a case that is not manageable? The Court of Appeals said that that's not a reason to dismiss. But also on the question of the federal regulations doing away with the California Labor Code, that was remanded or sent back for the trial court to decide. So we don't know what happened there. And finally, the Court of Appeals did mention that the evidence or the records of the employer showed that they did not necessarily comply with all the meal periods, and all of the meal periods were not properly taken by the employees. And that generates a presumption based on a case from the California Supreme Court, the Donahue case, that essentially ruled that if the records of the employer show a violation of the meal break, then there is a presumption of violation, which the employer then needs to bring evidence to disprove or to prove that there was no violation. And in this case, the court is bringing that up. The Court of Appeal is bringing the presumption created by the Donahue case. And although things convoluted, it's pretty straightforward. From my perspective, this is a Court of Appeal bending over backwards to make sure that a PAGA case continues and maybe a wage and hour class action case continues, when maybe on the facts, it should have been dismissed. Too harsh?
No, no, but I think the takeaway from this goes back to the threshold issue. The court remanded for further proceedings, saying it's a fact determination whether there's a federal preemption of California meal and rest breaks to begin with. Are these local truckers? Are these interstate truckers? Did the load come from interstate? And that's a threshold issue. Just like we were talking about the FAA and the CAA in that other case, this is the same thing. The Court of Appeal said, look, do first things first down there, would you? We're sending it back for you to determine whether this should even be heard under this rubric or that rubric. Is this a federal case? Is this a California case with regard to trucking? Because trucking is extremely complicated with regard to that preemption. And personally, I don't even like taking trucking cases because I feel like every one of them is going to be preempted by federal law.
It's not even law, it's a federal regulation, which, as a matter of coincidence, has survived several administrations. So this is one of those third rail issues that Congress seems to be ignoring because the technicality is not even based on a federal law. So I understand what you're saying. You're saying it's like answer the question, does the federal rule preempts California Labor Code? Big
Mhm.
question. And in this case, it seems to have been answered. It's like, well, we don't know yet. Go back and answer the question again. In the other case that you discussed, George, in that case, the question was not even brought by the parties. So in that case, the Court of Appeal imposed an obligation on the trial court to answer the question. So I agree with your analysis that the Court of Appeal seems to be saying, trial judges, do your homework, please, right? We have enough cases, maybe? Maybe. So one more. Let us talk about briefly on the holding of the Court of Appeal in the case is called Prime Healthcare Management v. Superior Court of San Bernardino County. And this is a case from San Bernardino, of course, in which there was an arbitration case. And in the arbitration, we have to deal, and the court in that case had to deal again with PAGA. Interestingly, we have PAGA, and there was a recent amendment to PAGA, where I'm going to call the new PAGA. So under the old PAGA, this case began under the old PAGA. And now under the new PAGA, there is a standing requirement. And what the Court of Appeals have said under the new PAGA is that if the case is forced to arbitration and the employee has to arbitrate their individual PAGA case, their individual PAGA claim goes to arbitration. If the employer wins, that's it. The employee does not have standing to bring that violation back to court for the benefit of all of the other employees that were affected, all of the aggrieved employees, because the employees lost the standing by losing their case. In the old PAGA, the employee only had to have one violation, and one employee can represent everybody for all violations just because that's what the law says in 2004. But now that the law changed 20 years later, if the employee loses in arbitration, they cannot go back to court to represent everybody else. Makes sense to me. But in this case, the Court of Appeal said that because this case began under the old PAGA, tough luck. This employee, even if they lose in arbitration, they may have the chance to represent everybody else for all of the violations back in court in San Bernardino. So my response is, wow, the old PAGA is not going away anytime soon. So for all that have cases on their old PAGA, be careful because the intersection of arbitration and PAGA is changing, but the old rule still applies. That arbitration really doesn't help in PAGA cases, right, George?
That's right. And PAGA has a pretty short statute of limitations. So I think like the Ending Forced Arbitration Act, I think this will also eventually just die away because at some point all of the old PAGA will be barred by the statute of limitations. So I suppose PAGA attorneys need to learn this, but relief is in sight. Time will take care of this wound.
Maybe not. I recently participated at a conference where the PAGA issue was being discussed, and somebody brought statistics looking at the filings with the labor workforce development agency, and it seems that for the year of 2025, there was one law firm that filed 300 PAGA notices. How can one law firm file 300 PAGA notices? My speculation, and I don't know the law firm, AI. So maybe with AI, PAGA is going to increase, not decrease at all. So stay tuned. The PAGA may continue, and it seems to me that it's going to continue for a while. George, comments,
No
concerns?
further comments on that pocket case. I still think that Father Time is undefeated.
I'm sorry, I missed that. The PAGA?
Father Time is undefeated. Eventually, everything changes.
Agreed, agreed. And hopefully PAGA will go away. And I'm not opposed to something that actually helps employees, but the way PAGA works now may not be in the best interest of employees. So hopefully Sacramento does something about that. But in the meantime, we know the rules: old PAGA, new PAGA, arbitration, hot topics still in 2026. These are the cases published in December of 2025. We're going to do this again next month to bring the cases that were published this month, January 2026. Our sponsor again is Veritas Workplace Investigations. If you need an investigation in English or Espanol, Veritas Workplace Investigations. Please follow, subscribe to this channel so you get our new and from time to time responses and comments and opinions as to the cases published by the Court of Appeals and anything that we find interesting, George and I, on employment law in California, so we can all navigate employees, employers, California employment law. With that, George, I thank you for your time, and thank you everybody for watching this video. See you soon.